Record. Okay, yeah. Hello, everyone. Welcome to today's webinar. Topic is latest developments in data protection, guidance from DPAs across Europe. So we will look on the latest developments, latest guidelines, some court rulings, etc. What's new in the data protection world. Quick overview on what we're doing. Yeah, welcome is now. Then we have a webinar. We will take about 30-45 minutes, something like this. After this, we will have some time for questions and answers. You can put your questions into the Zoom chat function here. So in this navigation bar that you have in your window, in your Zoom window, you should see something like chat or frequently asked questions, something like this. So feel free to put your questions in there. We collect them and will answer them after the webinar, depending on how much time we will have. We will also record the webinar and put it, the webinar and the PowerPoint presentation, etc., everything on our website later on consentmanager.net. So that's for the welcome phase. Then let's go into it. First section or first topics, current guidelines from DPAs and court rulings. I've collected 5-6 different ones, the most recent. Let's start in Germany, TTDSG, so that's the German e-privacy equivalent. So Baden-Württemberg, one of the German states, issued some guidelines in March on how to deal with cookies and tracking and everything that's related to this stuff. Some, let's say, highlights from the guidelines. Not very surprisingly, no consent is only no consent required is only in cases when the purpose is really necessary. So, for example, shopping basket cookies, language cookies. That's all. There's no consent necessary for this. Storing the consent status obviously is you don't need consent for that. For this, there is a explanation or a note to this saying that consent status should only be stored without any ID. So the user should not have an ID. If you're using Consent Manager, by default, we're not setting any user IDs, so you don't need to do anything. If you enable the ID setting in your Consent Manager settings, then maybe you wanna think about disabling this ID feature. And the third example is security functions, so things to prevent fraud or simple things like submitting a form multiple times. That's also things that don't need consent if you're using cookies for this. All non-essential third-party tools will fall under GDPR or TTDSG. That's also nothing really surprising. Some examples for third-party tools and how to resolve the issue of consent or of this tool that Baden-Württemberg is giving. So the typical two-click solution, what they call it. So that's the when you have, let's say, a YouTube video, and instead of loading the YouTube video, you will have a layer on the place where the YouTube video is, and then you just click on say, yes, I accept to watch the YouTube video now, and only then YouTube will load. Another suggestion from the DPA is, for example, for Twitter, you should use screenshots instead of the embed. So you just take basically a picture of the embed, and then you put the picture in your website. Obviously, that doesn't allow so much functionality, but if it's really just about quoting some tweet or some content, then this could be the data protection friendly version of embedding content. YouTube videos and Google Fonts, the recommendation is, put them on your own server. Don't use the YouTube integration. If you put them on your own server, then you don't need consent for this stuff. And for maps, the recommendation is, for example, to use OpenStreetMaps, or there's other ways that you can use maps that are a bit data protection friendly. So that's examples that Baden-Württemberg is giving. No consent for analytics. So they give some examples when analytics doesn't require consent. The examples are very limited on functionality. The 4 examples is on the one hand, log file analysis. So if your server is producing log files, which can be also an issue. So you might want to limit the production of log files. But if you have log files, then in some cases you could use them in order to, create analytics from it. The second option can be if you're using an analytics tool that is not from a third party and is not external. So examples would be, for example, Matomo. So analytics tools that you host on your own web server there can be situations when they don't require consent. Also, a requirement is that they don't merge data with other sources, and that you limit the purpose on only analytical things. So you should not repurpose or reuse the data for other purposes, for example, for marketing. If these things are given, then analytics might not require consent. In most other cases, basically in all other cases, analytics will require consent. Then what also Baden-Württemberg did, it's kind of new to data protection authorities, they gave some examples on how a cookie banner should look or how it should function. Unfortunately, they did not give positive examples. They just gave negative examples, so meaning they listed the common mistakes, and I've collected some of the let's say more interesting ones. So on consent requirements, they gave examples like obviously you should not use or set any non-essential cookies before consent is given. Consent must be as easy as rejecting the cookies. The reject button must be visible also on small screens. If it's not visible, then one could argue that it's harder to reject than to accept. So it should be, of equal prominence, the accept and the reject button. Some mistakes that they collect in regards of the information. So if you're having a German website, the German target audience, then the cookie layer should also be in German, or at least offer a German option. It doesn't need to be in German. If the user is English, for example, and you offer German and English, that's totally fine. But at least you should offer German language. The cookie banner must have sufficient information. So just a click or a link to the privacy notice is not sufficient. There needs to be some text in the cookie banner explaining certain things. We will go through through some examples later. And there must be info on processing personal data, not only on cookies. So although it's commonly known as a cookie banner, it is more than this. It's a consent banner, and so you also asking for consent for processing personal data, so that needs to be in there. What was also interesting from the guidelines is they give some examples on bad headlines. For example, we love cookies, or welcome, or we need your consent, accept cookies, we respect your privacy. That's all headlines that Baden-Württemberg is saying is too unspecific. So the headline should be something like consent on cookie and data processing, something like this. So it should be clear that it's about giving consent, and it should be clear that it's about cookies and data processing, or cookies and data, something like this. So something like we bake the best cookies, etc. is fun, but it's not compliant when it comes to the data protection authorities in Baden-Württemberg. And again, also should not come as a surprise, but legitimate interest is not seen as an adequate legal basis for analytics and personalized ads and device access. So you will need to ask for consent for most cases for analytics, personalized ads, and stuff like this. So that's Baden-Württemberg. Then we take a look at Latvia, the DVI, that's the Data Protection Authority in Latvia. They gave some guidelines on cookies. Again, it's very similar to what other countries say. So no consent will not be required if it's a first-party cookie for example, shopping carts, authentication, security, fraud prevention. So basically the same stuff as the Baden-Württemberg is saying. Some things that they have or seem to have see a bit less critical. They, for example, list technical cookies for media elements and load balancing. That would include things like YouTube cookies. User customization, so that's quite normal. But then again, they say sharing third-party social media content. So they specifically list this as a non-essential, as a non-consent example. So a Facebook button, or it's not 100% clear what they mean, but you could understand that this could mean a Facebook button or a Twitter Twitter share button or something. So they would assume that this does not need consent. I added an exclamation mark to this because, yeah, for most other data protection authorities, yeah, the guidelines is, let's say, different. They also say that they like to see clear language. Clear language meaning you should avoid words like may, could, some, often, possible. So all words that are not 100% clear. So you should rather say something like, we will store data and not we may or we could store data or something like this. Same for the purposes. They like to see very specific purpose descriptions. One example that they give is we will store your shopping history and use your information on previously purchased products to recommend other products that in our opinion are in your best interests. Yeah, so my English, sorry for the English there, it's a bit I translated this yesterday from Latvian language, so it's yeah. But you get the feeling. So you should not say something like we use personalization, but you should say something like we store your shopping history for yeah, recommending you products that might fit. So as specific as possible. Again, opt-out must be possible via the banner. So it's not sufficient to just point the user to a page where, you know, where it's explained how you can delete cookies in order to reject basically, or to reset your settings. So if I can accept in the cookie banner, then there must also be a reject way or a way to refuse. And they gave an example on how they like to see cookie descriptions. I picked two that we usually see with our clients. So FBP, that's the Facebook cookie name. And the description that they gave is use facebook.com to deliver ads 3 months expire time. So that's very, let's say, also very Latvia specific. Most other data protection agencies want to see a bit more explanation. The example for Google Analytics is use Google Analytics to adjust number of requests. So that's for the one cookie. There's more cookies that Analytics is setting. But again, so it's yeah, it's short. So they highlight that they like to see short and precise explanation. Not sure if other countries would see this as sufficient in this case, but at least if you're targeting Latvia, then that's the way to go. Next country, looking at Austria, there was a recent court ruling. The NOYB, that's a yeah, a company, not really a company. It's a, how do you say, a Verein that is on, you know, specializes on data protection. They filed about 100 or 101 complaints in basically all over Europe. on this topic specifically, so Google Analytics and the use of Google Analytics on websites. In Austria, it basically was the first country where it really got to the highest data protection authority and where they actually decided something. The decision there is that Google Analytics is seen as in violation of Schrems II decision. The Schrems II decision is the one that basically kicked the privacy shield. The conclusion is that Google is seen as a FISA vendor. FISA, that's the American law that allows data protection, or not data protection, agencies, so CIA, FBI, etc., that allows them to access data from these vendors, and the DSB, so the Austrian data protection, they see that Google will fall under this, and therefore US agencies may access this data, and therefore basically the data is not secure, securely stored in Google Analytics. I see some questions coming in. 2 questions on the slides. Yes, the slides will be available after the presentation. So we will put the video and the slides, the presentation on our website after we finished here today. Yeah, Google Analytics. So Google Analytics is seen as not compliant. Also the SSCs, so the standard contractual clauses and the technical or organizational measures that Google is offering are not seen as sufficient protection against the sharing with the US vendors. And in conclusion, the website was sued, or the authorities said that the website needs to remove Google Analytics. There is some similar cases in basically across Europe. As said, the Austrians are the kind of the first ones that decided on it. There is, I think, the Netherlands kind of jumped on the same train and came to a similar conclusion, or said that they will come to a similar conclusion. Not sure if they decided something yet. France also decided in a similar case. So it is very likely that the other data protection authorities in Europe will come to the same conclusion. And again, that will mean that Google Analytics might not be compliant. You might need to have additional steps in order to secure Google Analytics, and you will very, very likely not be able to use Google Analytics without consent. So that's from Austria. Yeah, France, as said, France also has a Google Analytics case. Also, the recommendation that France is giving, or the CNIL, the French Data Protection Agency, again, accept and reject must be present, must have the same size and the same font. Size in this case, so they're actually writing size, so the button size. So you should not have a small button and a big button. Again, it's about dark patterns and this kind of stuff. So you should have a design that doesn't pay too much attention on accept button and tries to hide the reject button. They also mentioned something, let's say France specifics, a button, they call it continue without accepting. They see this as another option that can be offered as an option to reject. Usually this button would be on the right top corner, so where you usually have the close X in a window. There could be a link or a button saying continue without accepting, which is rejection. Some publishers in France use it in a way that if you click this button, you're rejecting, but you're rejecting for a shorter period of time. So if you click on the normal reject button, you reject for, let's say, a year. But if you click on the continue without accepting button, you only reject for, let's say, a day or 7 days, something. So that's how some publishers in France use it. There's also a recommendation to have the option to change the choices. They specifically talk about having this change icon in the left bottom side of the website. So that's where we typically have yeah, or preference button. So if you're using Consent Manager, the default setting is exactly this. So the left bottom side. They don't say that you can't use any other way, but basically that's the usual way how they would expect it. So that's France. Belgium. Belgium took a interesting case on the IAB transparency and consent framework. That's the standard for the advertising industry. The goal there is basically to signal the consent information to to your advertisers on your page, etc. The APD came to the conclusion that the standard is not GDPR compliant, so it's violating GDPR. There is several findings or several conclusions. One conclusion is that the IAB will need to pay some money, 250,000. That's roughly, I think that's roughly the 4% of the annual turnover. So it's kind of the maximum, so to say, what you can pay. They found several issues. For example, legal basis are missing. The transparency on the purposes is not high enough. So the descriptions basically is not sufficient. There is insufficient mechanisms for fraud prevention. So it's a lot of things that are basically baked within this framework, within the standard. There's also issues on how the IAB as the organization is acting. For example, they are seen, or the APD sees them as the controller, and if you're the controller, then you have some obligations. For example, you might need to appoint an DPO, you need to make some DPAs, or you need to create a data processing directory. All these things the IAB did not do because they did not see themselves as the controller. So that's things that they now need to do. The next steps for this is there is the action plan that they need to submit, or that they actually submitted already. The action plan is basically the IAB needs to outline what changes they think, or what changes they want to apply in order to make the TCF GDPR compliant. This action plan was submitted, I think, beginning of this month or mid of last month. So it was submitted some weeks ago. They're also obligated to appoint a DPO and do some legal requirements. Basically, the APD will now check the action plan, see if they, if they're fine with it. If they agree with the action plan, then the IAB will have 6 months to implement the action plan, and then basically change the TCF accordingly. It is expected that the APD will not give any feedback before end of June. So maybe then in June, July, there will be some work on the TCF. For publishers that are currently using the TCF, because I mean most publishers that have advertising on the page will probably need the TCF as a standard. So if you're using TCF, then at the moment it's really hard to give a recommendation. From a business perspective, it's probably the only way to work. From a legal perspective, if you can avoid it, try to avoid it. So that's Belgium. It was our little look across Europe. As said, most of the data protection agencies or authorities, they have very, very similar guidelines. I yesterday also looked at the Dutch and the Spanish. They also have guidelines. They're all very, very similar. And from all these guidelines, we basically compiled some recommendations on how your cookie banner should look like or can look like. That's the first layer. So you will have a box. You will have 2 buttons, an accept button and a reject button. They should both be present on the first layer. They should have the same design, same size, same color. Or if you use different colors, then the colors should indicate what they're doing. So something like if you have a water tap, for example, you have the red for the hot water and the blue for the cold water. If that's something that's common, or for example, if your website is using red and green or something like this, that's a case where you can have maybe different colors, but if the colors are, let's say, yellow for the accept and gray for the reject button, that's probably not very compliant. The button should have clear labels, so name them accept all, something like that, and reject all, and not something like okay or continue or something like this. You should not use any dark patterns, as described. Don't highlight one button and put some other button in the background. Also, these things where you have a settings button and an accept button, most data protection authorities, so the guidelines, clearly say that you need to have two clear buttons with rejected. So a settings button and just some reject link in the text is not sufficient. As we just learned from the examples before, you should have a clear headline that talks about consent, data processing, cookies. In the text, you should also have a sufficient description. You should tell that it's you and third parties processing the data or setting cookies. Some authorities actually want to have the amount of third parties. So we had cases with clients where the authorities said you should write something like, we and our 53 partners collect personal data, etc. So they wanted the number there. It's rare cases, but we have some cases. So if you can, then put the number there. If you're using Consent Manager, we have a macro for this, so you can put basically a placeholder in the text, and the system will insert the number automatically. You should also list the purposes on the first layer. You should talk about that it's about personal data and cookies. You should talk about how to reject, etc., etc. So there's more information that needs to go in there. You can also check we have a checklist that you can look what you need to put in the text. Also, as we learned from the Planet 49 case, I think in 2000, so 2 years ago, you should not have pre-tick checkboxes, and you should have some links to your privacy notice, terms and conditions, imprint, etc. So all the legally required information must be accessible without accepting or rejecting before this. So that's the first layer. The second layer, so when you click on custom settings, or customize your choice or whatever the link is called. So first of all, you need to have custom settings because probably you don't get all the information in the first layer. So you need to have some way to show some more information. In the second layer, you could use basically you should list all the purposes. You should not use function or essential or however you call it for anything other than really essential things. As we learned before, analytics is not seen as essential. Most third-party tools will not be essential, so it really should be only your shopping cookies, or maybe if you're an online shop, maybe your payment providers, etc. So these things could be essential. Other things should not be in this functional or essential category. You should limit the amount of vendors. So we have cases where authorities basically say 200 or more vendors is just too much. We don't have a clear indication how many vendors are good, so how little you should have. From personal experience, I would say something like 50 or maximum 50. The reasoning behind this is basically if you have too many vendors, then a normal user will not be able to understand all this information. So you should limit the amount of vendors, basically meaning you should limit the amount of tools that you're using on your website. If you have many vendors because you have many tools, then you should rethink what you're using on your website. And yeah, as said before, if you want to use the TCF, rethink if you really need to use it. If you're an e-commerce, if you're an online store, if you have a normal website just for your brand or something, then you usually will not need the IAB TCF. It's probably just a thing for publishers and websites that have online advertising on them. Some info that is required in the second layer. So you should have a clear and explicit description of the purposes. So just saying marketing is not enough. You need to explain what marketing actually is. In general, marketing already as a name or as a word can be misleading. So in some of the guidelines, they say something like, using personal data to recommend you products, etc. That's much clearer than marketing. You need to list all the vendors. Even if you don't want to highlight some vendors, if they are processing personal data on your website, you should list them. You should list them with the name, with the address, legal basis, the purposes. You should have a description on the vendors, and you should name the categories of processed data. On websites, the categories is usually something like cookies, IP address, browser information, etc. But still, you need to name these things. You should also list all the cookies with the name and the storage duration. So that's the expire time usually. And the purpose. Some data protection authorities like to see a description there, as we saw with Latvia. Some don't care about the description. Some don't give clear guidance on the description. What is common is, or what all say is, you need to have the name and the storage. You also need to have granular choices, so it's not sufficient to just enable or disable purposes. The user should be able to basically within the purpose say, okay, within marketing, I want to allow, let's say, Facebook, but not Google, or the other way around. So you should have granular choices on vendor level, if possible, even lower levels. And you should also include information about your company, so you as the controller, and if you have a DPO, you should also list your DPO data. That might be the last two pieces, might be in your privacy policy, but it's always better to make it as easy, accessible as possible. If you're using Consent Manager, then there's an option for this, so that you can display this data in your consent layer. Another recommendations on non-EU data transfers. So all the vendors that are located outside of the EU, or vendors that basically receive or transfer or process data outside of the EU, they are, let's say, tricky at the moment. As said, the Schrems 1 and Schrems 2 court rulings kind of made it not impossible, but harder to transfer data into the US. So if you have vendors on your website that are US vendors or process the data in the US, you might need to add additional safeguards or additional nodes at least. So if you have vendors, let's say it this way, it's never an issue if you highlight something or if you say something that you have these vendors and that these vendors may process personal data outside of the EU, and that there might be a risk with this. The better way would be to explicitly ask the user for consent for these vendors, separate of the normal consent. So that would be the optimal case. As said, transferring the data outside of the EU may require additional consent. So there can be, if you're using Consent Manager, you can have some like a legal basis, we call it explicit consent, which basically only enables the vendor if the user explicitly clicks on this vendor button. So the accept all button on the first layer does not enable this vendor. So basically the user really needs to click and say, yes, I want to have this vendor. The important note there for this is it's not only about where the data is, it's also about who has access to the data. So basically who owns the server or the data center. So there was recent court rulings, I think it was in December, on a cookie vendor, on a cookie provider or cookie consent banner provider. They were using a US vendor as the server provider. The servers were located in, I think, Frankfurt, was it? So in Europe. but the data center and the servers were hosted by this US company, and the court found that this is not this also falls under this non-EU data transfers. So you really should check your vendors, not only where they're located, not only where the data is located, but also who owns the servers, the data centers, etc. We will have some notification on this in our cookie crawler with the next update on next Monday it is. So next Monday, the crawler report will not only tell you that, let's say Google, for example, is a US vendor, it will also tell you that the data center, if a third party is using Google as a data center provider, it will also highlight this, that this can be an issue. Yeah, that's the non-EU data transfers. Just a quick look on the time. Yeah, we're good. Data protection worldwide, a quick look outside of the EU. California and the US, that's basically one of the countries, or in this case, the states, where data protection is a bit more mature, or where the laws are more mature. The normal case in California is consent is usually not necessary. The normal mechanism is an opt-out. So basically you go on the website, everything is active, and then you search for the opt-out link and you say, yeah, please stop the sharing. CCPA or CPRA, so CCPA is the, let's say, the older law. CPRA is the addition, the clarification. It's a bit more specific. It's a bit more strict. It applies to Californians or to companies that do business in California or process personal data of Californian residents. It also applies if you have more than 25 million in revenue per year, or if you process data on more than 50,000 consumers per year. 50,000 is a quite low number. So that's approximately like 5,000 a month. So 5,000 visitors from California, that's a number you could easily reach, especially the bigger e-commerce list. So you could fall under CCPA or CPI, even though you're maybe in Europe or Brazil or somewhere else. You still need to check that this could apply for you. If it applies to you, then privacy notice will probably be required on the page visit. So a layer that is, let's say, similar to the European layers that we see, but a bit more simple. So usually you don't need this accept and reject. Usually it's sufficient to just have an OK button. Basically, you just notify the user and the OK button will just close the layer. You should have a do not sell my personal information, or under CPRA, the link should be named do not sell or share my personal information. So you should have this link on your page. The link must have this specific writing, do not sell or share my personal information. So it's specifically in the law, this text. You should have this text on your page, and this text should lead you to some opt-out page where it's possible to stop the sale or the sharing of personal data. Basically, that's the equivalent on saying reject in Europe. Enforcement is already ongoing. So the Attorney General of California published some, basically some things that they did last year. There is several cases where they specifically checked that the privacy policy is not present, that the notice is not on time, or that the do not sell link is not present. So the authorities are already checking and they're enforcing it, meaning you could get fines or get sued. There's other US states that have similar laws. In most cases, they're not so publicly discussed as California. California is a bit more in the media because that's where all these, the big tech companies are, and also California has more citizens. But yeah, let's say there is more states that where similar requirements are present. Next to the US is Canada. Very quick only. So the keywords for Canada is PIPEDA or CPPA. That's the law there. It's very much likely to GDPR. So consent is the default legal basis. Basically, you need consent for everything. They don't really focus on cookies. So cookies is kind of outside of Europe. Cookies is not really a thing. It's more about the actual sharing and processing data. Canada has something that's called implied consent. It's not 100% the equivalent of legitimate interest, but it's similar, but not same, you know, as they say. So there are situations where you can assume that consent would be given. As I said, it's quite similar to legitimate interest, but not the same. The scope of PIPEDA or CPPA is organizations in Canada and organizations with real and substantial connection to Canada. Whatever this means, the typical understanding of this would be if you're targeting US customers, or if you're, for example, if you have an online store and you deliver, if you have a delivery option to Canada, then this could be seen as yeah, real and substantial connection to Canada, and therefore you might fall under PIPEDA and CPPA, and then you would need to request consent for the similar issues as in Europe, so analytics and all other third-party data sharing. A bit more global view. So America, or in Americas, you have Brazil with civil law or with a similar law, Mexico, Argentina, Africa, several countries, Nigeria, South Africa, so that's the bigger ones. Asia is South Korea, China, Thailand. I think Japan is also missing on the list. They also have laws on data protection. Middle East, Turkey, Russia, Israel. So there's a lot of countries that already have data protection laws in place or are basically currently developing them. So it's good to you know, focus, good to check what's your you know, what's your as we had in with Canada, are you affected by these laws? Do you, for example, offer shipping or delivery into these countries? Do you target specific campaigns to these countries? Then these laws can apply to you, and you might need to want to have a specific cookie banner or consent banner in these countries. Okay, so that's the quick overview on this. Thank you so far for these for your time. Please still feel free to insert questions in the chat or the FAQ section. We don't have so many at the moment, but let's see. I will just read some of them. Can you use the same Google vendor for all different Google tools, or do every different tool, ads, tag manager, fonts, etc., need the specific Google vendor for each tool? Yeah, so if you're using, let's say you're using Google Analytics and Google, I don't know, Maps and reCAPTCHA, etc., on your page, granular choice. So yeah, GDPR likes to see granular choices, or the data protection agencies like to see granular choices. It's not 100% clear what granular means. If you can, basically, if it's technically feasible for you to offer these granular choices, and then I would say yes, do it. Separate Google Analytics from Google Maps, etc. Also, the purpose behind the two tools are quite different, let's say it this way. So it makes sense to separate them. Not in all cases it's 100% possible, technically possible, especially with the Google tools. You will have a lot of tools that basically use other Google tools. So for example, in Google reCAPTCHA, is usually also using the Google fonts to display the text on the reCAPTCHA. So by inserting the reCAPTCHA in your page, you will also automatically get the Google fonts with it. And you don't really have an option or a possibility to separate these two things. So yeah, as I said, if it's technically possible, separate them. If not, then at least, yeah, get the description right, you know, put the vendor description in there, list everything that you do with Google or with these vendors, and make it clear that there is not only analytics or not only maps, but also, I don't know, reCAPTCHA or fonts or something. Mm-hmm. Any other questions? Please feel free to put them in the chat. It's a very quiet chat today. Otherwise, if nobody has any other questions, then we give you some time back, 10 minutes, and stop the presentation here. Then, yeah, I thank you for your participation. Remember to register on your page, on our page, share us on LinkedIn, etc. And as I said, we put the video and the PowerPoint on our website. Thank you and goodbye.